to have been through post. When the specific stipulation was made regarding process to be conducted online, no rejoinder to the counter affidavit has been made. The counsel for the respondents has referred to the counter affidavit filed in WPS number 4936 of 2023 for consideration in WPS number 5768 of 2023 by stating that the judgments passed by the Honorable Supreme Court may be taken into consideration for the purposes of disposal of the case, which is in public domain. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the entire recruitment process relates to advertisement regarding recruitment published by advertisement number 21 of 2016 and from the perusal of advertisement, it is apparent from paragraph 4 within bracket G within bracket Roman 8 that all the information regarding examination and other information regarding examination would be made available through website. Including the result. Clause 4 within bracket G within bracket Roman 8, Roman 10 and Roman 8, Roman 9 and Roman 11 are quoted as under. It is not in dispute that all the applications were submitted online. This court finds that the fresh counselling started pursuant to the orders passed by the Honorable Supreme Court.
But she was given opportunity in the year 2019 twice.
I will come to that. Pursuant to the order passed by the Honorable Supreme Court in the case of, you should give me a copy of these judgments of the Honorable Supreme Court, right? You have just mentioned it, but you just provide me a copy. A soft copy would be sufficient. In Civil Appeal number 4038 of 2022, Sanjeev Kumar and others versus State of Jharkhand and others, and other analogous cases, wherein two orders were passed. One is dated 2/8/2022 and subsequent order dated 2/12/2022, which are quoted as under. I want both the orders, 2/8/2022 and 2/12/2022. It appears from the counter affidavit that in order to comply the orders of the Honorable Supreme Court, by which a direction was issued to complete the entire recruitment process within a period of 3 months from the date of the order without fail, the candidates were called for document verification through website. Such communication through website was certainly in accordance with the advertisement itself. This court is of the considered view that merely because some communication was received by the petitioners through email, the respondent was under any legal obligation to make further communication through email only. Once there was a clear stipulation in the advertisement that the communication in connection with the examination would be held through email, through website. Further, the respondents have also explained the time constraint with regard to the completion of entire exercise, and many candidates had participated pursuant to the publication made, intimation given through the official website. This court also finds that the Honorable Supreme Court had clearly stipulated that the High Court shall not clearly pass a restrained order, that the High Court shall not pass any contrary order with respect to the recruitment in question. This court is of the considered view that if the relief as prayed for by the petitioner in WPS number 4936 of 2023 is granted, the same would amount to extending the time period prescribed by the Honorable Supreme Court. And in view of clear order passed by the Honorable Supreme Court, restraining the High Court from passing any contrary order with respect to the recruitment in question, this court is otherwise also not inclined to pass any such order as prayed for by the petitioners in WPS number 4936 of 2023. So far as the writ petition being WPS number 5768 of 2023 is concerned, the petitioner was called upon for verification of certificates way back in the year 2019, and her explanation for not participating for verification is not acceptable in view of the judgment passed by the Honorable this Court in WPC number 1522 of 2019. The relevant portion is quoted as under. Considering the totality of facts and circumstances of the present case, this court is not inclined to issue mandamus as prayed for by the writ petitioners. Accordingly, the present writ petitions are hereby dismissed. There will be some changes in the final order. I am saying so because these are all online proceedings, right? These are all published online. It is there in the YouTube. So don't start quoting up my dictation and say that there has been change. There may be changes, maybe some reasoning I will add. It's an open court dictation, but the final outcome will remain the same. Anything else I have left? You just let me know. Is there anything I have left? Any part of your argument I have left?
No, so वो जो merit list बनने का बात था,
No, that is
if that finds relevance,
it doesn't. It is absolutely irrelevant. 2019, you were given an opportunity, and I don't think that there is a provision for second opportunity.
not the provision for second opportunity. It was stated like after all the cases that happened in the Honorable Jharkhand High Court, it went to the Honorable Supreme Court. Supreme Court says that आप जाइए और एक fresh merit list prepare कीजिए, and accordingly you do this recruitment.
Anyways, you have not participated. You have not even visited the website to find out whether your name is there or not.
That our mistake is already there. Let's we cannot run away from that.
Congratulations.
Item 5 WPS 5418 up to 2023.
Council for JPSC, where is he? Provide me the orders. I don't know, where is he? Where is the council for the other side? Yes, like, I need those orders of the Honorable Supreme Court. Kindly provide it. Kindly ensure, right? Yes.
Madam, this is the case of computer operated also. It is in place of quashing of annexure 21. Because of
The file one IA.
yes, one IA for including party in serial number 5.
You first include, allow the IA.
Yes.
IA number 10316 of 2023 and WPS number 5418 of 2023. This interlocutory application has been filed for addition of party. It is the case of the petitioner that whom do you want to implead?
Madam, Rishikant Upadhyay. It is given in
Where is the detail?
yes, detail is given in paragraph 1 itself.
The counsel for the petitioner has submitted that in place of the petitioner now one Rishikant Upadhyay is working
Yes.
through outsourcing agency. And therefore he is a necessary party in the present case and be impleaded as respondent number 8. Counsel for the respondents has no serious objection to the prayer for impleadment. Any objection? Considering the aforesaid facts and circumstances, IA number 10316 of 2023 is hereby allowed. Of the petitioner is directed to carry out the necessary insertion in the cause title in writing during the course of the day. Issue notice to the newly added respondent for which requisites under registered under speed post and ordinary process be filed by Monday.
Madam.
Office is directed to track the speed post delivery and prepare appropriate office note with regard to service of notice. Post this case on
बी सिमिलर मैटर में एक बार खाली वो दिखा देना चाहते हैं क्या प्रॉब्लम हुआ है केस में व्हाई दे आर डूइंग इन इंटायर स्टेट यूनिवर्सिटी सिर्फ एनेक्सर 21 है बताइए
on 28th March.
एनेक्सर 21 व्हाई दे आर स्टेट ऑफ झारखंड मिसइंटरप्रेटिंग दिस लेटर यूनिवर्सिटी पेज नंबर 173
You see, the point is that maybe that at one point of time in 2013, they must have thought that they will sanction the post, but they have not sanctioned the post.
till date not sent
So you are not seeking a direction for sanction of post. Are you?
not एक बार खाली ये एक
And
वाला
you
line
see,
है
it is
two
for
line
the
I want to address your
See,
only 2 lines
It is for the
how this
state.
letter is applicable on my only 2 lines I
No,
I
you
may
just
permit
tell
to
us.
say.
You are the relief that you are seeking.
Madam.
You were not working against a vacant sanction post.
My lord, this issue has also considered in recent judgment your Dharo Urao delivered by this honorable court on 15/1/2024 your lordship. Entire
Division bench?
no this is the
It's single judge. I have dismissed it. That you will
And-
not cite.
and
You
that-
will have multiple orders from different courts, isn't it?
your lordship.
I have dismissed one case. You want same order?
No.
So
Only
I'm
I want to
aware.
address
I have
only
dismissed one
two
case.
line only.
That is
my
also
lord, can
pending
you see?
before division bench.
My lord.
On the same issue, I have dismissed a case. That there is no sanction post, no vacant post. You cannot claim any relief.
My lord, so far the sanctioning of the post your lordship.
I am not dismissing it because let the notices be issued. Let us see what happens. Let us see
सिर्फ
what.
annexure 21 पे जवाब मंगवाया जाए जो ये
No,
हम
I am
पे
not.
applicable ही नहीं है
I can only dismiss it because I have to follow my orders also. You do not cite the orders of other court.
I am citing
No,
Babita
that
Kumari
is a
case,
practice.
same department your lordship.
That is a practice in Jharkhand High Court. that whenever one order is passed, you do not cite that order in other court where similar matters are coming up.
My lord, this case.
So this kind of practice is, creating a lot of problem for us.
So far, these two cases are concerned, Your Worship, the same department, water resource department, and so far this case, Your Worship, Honorable Division Bench also passed in favor of these petitioners, Your Worship.
I don't know. Then this case has become infructuous.
No.
If the division bench has passed order in your favor, then this case has become
My lord,
infructuous.
they have not followed that order.
We do not. In
Second,
WPS, you have filed your counter?
No, Your Worship, not.
Okay. There is no impediment. There is nobody is working in your place.
no. In this case,
But you have discontinued since 2022.
no. I have worked my discontinuity after filing of both cases, Your Worship. When I have filed
Where
this
have you
case,
stated?
yes, Your Worship. In first case, I have.
No, you forget about that case. Now, in this case, where
Yes,
have you
yes.
stated? You were extended only till 2022.
No. They have taken. I have annexed entire documents, Your Worship.
You have annexed all the documents.
Yes,
Let us
yes.
see your documents. What is your last extension?
Last extension, Your Worship, is of 2022. 30/11/2022. Page, kindly see page number
Yes, yes.
174. Thereafter, they have taken over from me, and I have.
No. You see, the last extension was up to 31/3/2022. That is your statement.
उसके बाद एक और लास्ट है एनेक्चर 22 देखा जाए 174.
No, you come to your. I go by writ petition. Averments made. in
हमारे
your-
एनवायरमेंट भी है उसमें. वो सेकंड उसके बाद.
Show us. Where is
Yes.
that?
Page
Where is
number-
that subsequent extension?
Yes. Annexure 22.
No,
Page-
not annexure. You tell us from the writ petition.
Yes.
Because as per your writ petition, last extension was done up to 31/3/2022.
उसके बाद देखा जाए annexure 22.
उसके बाद क्या देखेंगे?
उसके बाद paragraph-
WPS number 5486 of 2023. Council for the
paragraph
parties are
27 में
present.
देखा
Council
जाए.
for the respondents is directed to
Paragraph
seek instructions and file a
27.
counter affidavit in the present case.
Paragraph 27.
How much time do you need to file a counter?
4 weeks.
Okay. Pose this case on
Item
28th
6.
March.
In serial 6, Your Worship.
Yes, serial 6, yes. Pose this case on 28th March. The counter affidavit should be filed by 18th of March.
Paragraph 27 में लिखे हैं.
There are other, you will represent all of them? All the respondents?
एक ही.
Technical advisor, Bharat Circle, Galudi, Swarnrekha Multipurpose Project.
सर स्टेट करेंगे सर. Till September 2023, they have taken work, Your Worship. They have not released the salary when Your Worship.
No order of extension. We do not.
From
But they
date
have allowed to discharge work, Your Worship. It's his
from date is
document,
item
Your
1,
Worship.
criminal division 742 of 2022.
This petition.
Yes. This revision application is against the original maintenance case asked on 12th date 2000 of April 2022. Ex-party Lordship.
You never participated.
Lordship, in this case,
Notices were
Only
served
you.
on you.
only Gruhans, only thing, the quantum of the maintenance, which has been purposely passed, Lordship, by the learned court below. The 62,000, my salary has been given on the date of Lordship that was passing this order. But Lordship, I have given the salary slips.
No, you just come to the salary slip which was exhibited before the learned court.
That is 62,000. I have added with 27,000 as an educational allowance. For that, Lordship,
Where
it
is
is
that?
62,000.
Where is that?
That has not been. I have not appeared.
You have not appeared, you will not even obtain certified copy.
I have certified copy, but that fact has not come because I had not been examined on that in this case.
The matter was ex parte and you did not appear. So nobody
Lordship.
can force you to appear, isn't it?
Lordship, I have not been given opportunity by the learned court below. So I have not been.
I just don't understand. Notice is issued to you, you don't appear. And you say that you have not been given opportunity. Was notice never served on you? Is it your case that it was never served on you?
I'm just seeking instruction, Lordship.
You seek instructions.
He has never received any notice, Lordship, as per instruction. If notice, in spite of notice, if opposite party is not appearing, publication is there, Lordship. There is a procedure. That also not maintained.
He is the client.
Yes, he is the husband.
So we can take his statement. Please hold on. Please hold on. We can take his statement as correct.
His statement may be.
Come to page number 3, para 4.
Para 3 is
Page
with
number?
regard to notice.
Page number 3, para 4.
Of the
Para 3.
now
Para 3 by.
Para 4 also.
Para 4 is also. Para
and for securing the appearance of OP notice.
Para
was-
4, please. Read para 4.
I'm reading from 3.
You read para 4 straight away.
Now the point of
Para
determination.
4,
Para 4 I am reading.
not the impugned order. Your
Yes.
petition.
petition, you have admitted.
Page number 3, para number 4.
You have admitted that you are notice submission.
Was appeared before the learned court below, but the learned advocate neither informed the petitioner nor
So
filed
you
any-
cannot say that he did not receive the notice. He's an educated person or he's a person on the street. He's telling lies in the open court, instructing you and you are taking his instructions
Lordship,
contrary to what is mentioned in the in your petition. What punishment should we impose on him?
I beg your pardon.
No,
Lordship,
no,
it is-
no, no, no. No, he cannot get away by telling lies to the court. Right? And it is totally irresponsible on your part also. You have not read your own brief. You do not know what plea have you taken. And you are making a statement in the open court that the notice was never served on you. And therefore there should be a paper publication.
I am on the basis of
No.
Lordship quantum.
I
have
that is a
just-
separate thing. When I asked you whether the notice was served or not, if you say that you are on the basis of
That
quantum,
I
if you
overlooked,
say
Lordship.
that if you are it is on the basis of quantum, then under such circumstances,
Through
you did
my
not
submission,
appear at
I
the
start
test.
my submission with the quantum, Lordship.
Mr. Chakravarti,
I start
and
my submission
Mr.
with the quantum,
Chakravarti,
Lordship.
you have started, but a query was put to you,
Yes, Lordship.
right?
Yes,
Your
yes.
client in the open court is telling lies.
Yes, Lordship. That is, I admit.
Let
When
him
there is
also
a
admit,
statement.
yes.
There
You
is a
admit that you
statement.
are telling lies in the court. You are a government employee.
जी मैडम।
झूठ बोल रहे हैं?
नहीं मैडम।
फिर क्या ये क्या लिखे है पैरा नंबर 4 में? बिना देखे साइन किए हैं क्या?
एडवोकेट तो आपका अपेयर किया था ना?
हाँ, बिना
आता-
नोटिस के एडवोकेट अपीयर किया क्या? आपको सपना आया था कि आपके अगेंस्ट में केस चल रहा है?
नहीं मैम, हमको बाद में जब ये आ गया ऑर्डर आ गया था 20,000 रुपये महीना देना है तब
अबे हम नहीं सकेंगे उससे, ओके?
नहीं, I'm only on the basis, on the quantum, Lordship. I'm nothing in, I'm
Who's for the
admitting.
private respondent?
Yeah.
माइल आई एम अपियरिंग ऑन
कुछ पढ़ते नहीं है, कुछ लॉ का नहीं पता है. अब देखिए ऑर्डर हम आपके फेवर में करेंगे सुप्रीम कोर्ट जजमेंट साइट करके, बट यू आर नॉट अवेयर. I'm absolutely at a loss that there is no study done by the councils over there. Who is for the private respondent?
आई एम अपियरिंग ऑन बिहाफ ऑफ अपील टू मैडम।
You have seen this judgment of the Honorable Supreme Court. Rajneesh versus Neha,
माइल
right? This judgment was pronounced in 2020. When was the impugned order passed?
that was first allowed on
May
12 April 2022.
April 2022. There was a direction by the Honorable Supreme Court in all the cases. The required affidavit has to be filed in terms of the judgment of the Honorable Supreme Court. That was a direction under Article 142, meant for all the courts and in all the pending applications. But that has not been complied. And in this case, the quantum has been fixed on the basis of gross salary and not on the basis of net salary. A person, there are so many statutory deductions, right? There are TDS, PF. A person might be getting 60,000, 70,000, but maybe take home is only 40,000. There may be some other deductions on account of loan. All these things have been taken care of by the Honorable Supreme Court in this Rajneesh versus Neha, but there is no compliance with that. So therefore, the matter has to be remitted for fresh consideration.
But
And you'll have to
application
file.
was filed on 2019.
No, you see, आप तो रजनीश versus नेहा पढ़े नहीं, आपको कुछ पता ही नहीं. यहाँ कोई पढ़ने व लिखने से किसी को कोई मतलब ही नहीं है. कोर्ट में खड़ा होकर खाली हल्ला करने से मतलब. You see, what all affidavits are required to be filed in a pending maintenance case that also has been prescribed in Rajneesh versus Neha. What all disclosure has to be made by both the parties that also has been mentioned over here. That was required to be complied. That affidavit was required to be filed. I just... Where is that paragraph? There is a specific paragraph on that effect. You see, the affidavit of disclosure of assets and liabilities annexed at enclosure 1, 2 and 3 of this judgment, as may be applicable, shall be filed by the parties in all maintenance proceedings, including pending proceedings before the family court, district court, magistrates court concerning, as the case may be, throughout the country. So, this has to be done. I will fix a date. And also a time frame to file your affidavit. The judgment is here. You go through the judgment, prepare your affidavit, and I will fix a date that on that day you have to file all your affidavits.
Here or court below?
Before court below. Why should I do it here? Because that exercise has to be done by the court below. And you will have to find, since your client is here, you will have to file all your bank statements. You cannot disclose anything, and if you file a false affidavit, you are subjected to proceeding under section 340. That is also mentioned in this particular judgment. So please be aware. And if you do not file your affidavit, your right to defense will get struck off.
I have already filed one affidavit document over here, Lordship, which has been I purchased in the name of my wife.
So you have done a favor to her?
No. Some documents I have
That
filed.
is not that does not serve the purpose. So you are basically on the quantum of maintenance?
Yes, on the quantum of maintenance.
Learned counsel for the parties are present.
Therefore, I have not gone through anything. I mentally prepared that I want to.
But your client is not.
I know the fate
He's
of the
not-
case, Lordship. The quantum
He is
is
not
high.
above the board.
No, never.
Okay, quantum is not correct. According to you, what should have been the quantum? If the quantum is not correct,
Maximum, Lordship, 10,000.
10,000. So
Maximum.
So you will continue to pay 10,000 with arrears. You deposit that amount, and subject to final outcome of the result. Because relationship is not in dispute. Your employment is
Yes,
not in
yes,
dispute.
I am not disputing anything.
So at least
I am not
10,000
disputing
rupees,
anything.
the lady is entitled for 10,000 rupees right from the date of filing the application.
Filing the application nahi haudu, date of the, it is date also given in the judgment, Lordship.
Now in the judgment passed by the Honorable Supreme Court, it is from the date of filing the application. That is how.
Towards areas of equal installment within 10 months starting from May 2022.
But under the judgment of the Honorable Supreme Court, it is from the date of filing the application. So at least 10,000
And
rupees.
one son is,
You see, you cannot
they
say,
have 2 children, Lordship.
Mr. Chakravarti, you cannot recite from your own statement. You just now said that at least 10,000 should have been there,
Yes.
not more.
Yes, yes.
So you pay
maximum,
that amount.
Maximum 10,000.
You pay that amount subject to final outcome,
Lordship.
right? That would be the interim. Some kind of arrangement has to be made for the lady. That much of relief I can give you, and you deposit the arrears at the rate of 10,000 rupees.
Some installment.
What
may be given.
installment? You have
Lordship,
enough money.
Lordship, 30,000, 37,000 my net salary. I have to pay, if 10,000 it will goes around 2 lakhs, 3 lakhs rupees till the filing of. So 1 or 2 installment may be given, so that I can pay. Otherwise, again I will unable to pay, Lordship.
So from the date of the order is from which
May
date?
2022.
May 2022.
Yes.
Right?
Yes.
Order was passed from the date of filing itself. The
Where is
arrear
it?
amount has been directed to be paid from May 2022.
Where is the?
The order paper 11 of the interim order.
According to the opposite party, per month.
No, the maintenance amount will be payable from the date of application.
Yes, that is
It is mentioned.
Date of application.
middle order.
10th of 20. Allowance by 10th of each succeeding month.
No, and the maintenance amount will be payable from the date of
from the
application.
application, date of application.
Date of application is 10/6/2019.
10/6,
2019. Right.
2019.
10/6 was.
So you pay at the rate of 10,000, subject to final. This
Two installment. Mein.
I will give you 2 installments. Ask your client. Be very.
No, I'm just giving you Lordship.
For the arrears, right? 10,000 at the rate of 10,000
Lordship.
from the date of application. You will pay the arrears,
Lordship.
and that will be subject to final outcome of the case before the
Lordship.
right. The learned counsel for the parties are present. This petition has been filed against the ex parte judgment and order dated 12/4/2022, passed by learned additional principal judge, additional family court number 2 Jamshedpur, in original maintenance case number 159 of 2019, whereby the petition filed under section 125 of CRPC by the opposite party has been allowed, and the petitioner has been directed to pay a sum of rupees 20,000 per month to opposite party number 2 as monthly allowance by 10th of each succeeding month. There is a direction to pay the maintenance amount from the date of the application. The direction issued by the learned court below is quoted as under. Para number 11 को quote कर दीजिएगा at page number 40. The learned counsel for the petitioner has submitted that the petitioner is aggrieved by the quantum of maintenance as fixed by the learned court below, the relationship of husband and wife is not in dispute. There were 2 children born out of wedlock. One child is with the opposite party,
Yes.
number 2, and one is with the petitioner. He has also submitted that the maintenance has been fixed by taking gross pay of rupees 62,064, which was reflecting in month of July 2018. The Learned Counsel submits that there were additional payments made.
27,000 for educational allowance.
There were
May I have submit one thing for a 10 that is stated that net pay has been stated in the impugned order itself.
bills. The Learned Counsel submits that the same included educational allowance over and above the
साल में एक बार ही मिलता है.
salary of the petitioner. The Learned Counsel has also submitted that the impugned order was, should I put this Neha versus Rajnish
Yes.
in your mouth?
Yes, sir.
The
Yes.
Learned Counsel has also submitted that the impugned order was passed on 12th of April 2022 and the compliance of the judgment passed by the Honorable Supreme Court in case of Rajnish versus Neha reported in bracket 2021 bracket close 2 SSC 324 has not been done in as much as the necessary affidavit of disclosure of assets and liabilities annexed at enclosure 1, 2 and 3 of the judgment has not been done, though there was a mandate to comply the said judgment and file necessary affidavit in all the pending proceedings relating to maintenance. The Learned Counsel has also submitted that he has brought on record sale deed
Sale deed.
wherein a property was purchased
In the
in
name
the
of the
name of
opposite.
opposite party number 2 and he claims that the consideration of the said property was paid by the petitioner.
Yes.
You are just claiming, you do
Yes.
not know, right?
And salary slips
The
also.
Learned Counsel submits that the quantum would at best have been rupees 10,000 per month and not 20,000 per month.
Look.
He on instructions has submitted that the matter may be remitted to the learned court below and he submits on behalf of the petitioner who is physically present in
Yes.
this court that the arrears of maintenance at the rate of 10,000 will be paid to the opposite party number 2 subject to final outcome of the quantum of maintenance which will be ultimately fixed
Fixed.
by the learned court below. He has also submitted that he has no objection if any time frame is fixed for the purpose. Learned Counsel for the opposite party number 2 has opposed the prayer of the petitioner and has submitted that the petitioner has stated in paragraph 4 of the petition that he was aware and that his learned advocate never informed his advocate did not inform the petitioner and did not file any show cause on behalf of the petitioner. He submits that the statement indicates that the petitioner was served with the notice and he purposely did not participate in the proceedings and now it is not open to him to say that the proceeding was ex parte. And therefore, in revisional jurisdiction, the impugned order does not call for any interference. The Learned Counsel has also submitted that the payslip has been rightly appreciated by the learned court below and the same is an unimpeachable and undisputed document on record and therefore there is no illegality or perversity in the impugned order. However, so far as the direction contained in the judgment passed by the Honorable Supreme Court in the case of Raziz versus Neha is concerned, admittedly, the compliance of the same has not been done, right? After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances of this case, this court finds that the relationship of husband and wife between the petitioner and opposite party number 2 is not in dispute. It is also not in dispute that the petitioner is an employee in railways. It is the petitioner has come before this court challenging the quantum of maintenance, and during the course of hearing, as per the petitioner, the maintenance ought to have been 10,000 rupees per month and no more. However, the fact remains that the necessary, it is also the case of the petitioner that one property was purchased in the name of the opposite party number 2 and consideration was paid by the petitioner, but no material as such has been brought on record, and such new material cannot be appreciated in divisional jurisdiction, which was certainly not a part of the records before the learned court below. This court also finds that a judgment was passed by the Honorable Supreme Court in the case of Raziz versus Neha, reported in bracket 2021 bracket close 2 SCC 324, wherein the various aspects and different legislation in connection with payment of maintenance has been considered in detail, and appropriate directions has been issued by the Honorable Supreme Court under Article 142 of the Constitution of India with regard to filing of necessary affidavit of disclosure of assets and liabilities by the parties as enclosure 1, 2 and 3 of the judgment to be filed by the parties in all maintenance proceedings which were pending on 4th November 2022, that is the date of the judgment, throughout the country. Admittedly, the proceedings in the present case were pending before the learned court below on the date of the judgment passed by Honorable Supreme Court, and it was also reported in the year 2021 in Supreme Court cases. But while passing the impugned order on 12/2/2022, the learned family court has not taken note of the aforesaid judgment of the Honorable Supreme Court, which was widely circulated, and consequently the necessary compliance of the directions of the Honorable Supreme Court has not been done, which has resulted in dispute with regard to the quantum of maintenance. Even if the petitioner did not appear before the learned court below, but still the necessary disclosure ought to have been called for by the learned court below by the opposite party number 2 also. It is also considering the aforesaid facts and circumstances, the impugned order dated 12/4/2022, it also appears that as per the petitioner, the admissible amount of maintenance, as per the petitioner, at best, the maintenance would have been fixed at the rate of rupees 10,000 per month, and on instruction, the counsel for the petitioner has submitted that the petitioner is ready to deposit at the rate of rupees 10,000 subject to final outcome of the case before the learned court below, if the matter is remanded. Accordingly, in view of the aforesaid facts and circumstances, the impugned order dated 12/4/2022 cannot be sustained in the eyes of law in view of non-compliance of the order passed by the Honorable Supreme Court in the case of Raziz versus Neha Supra, and consequently there has not been complete disclosure of the assets and liabilities of both the parties. This impugned order dated 12/4/2022 is hereby set aside. The matter is remitted back to the learned court below for fresh consideration. The parties are directed to appear before the learned court below on बताइए date. बताइए 12th of March.
Lordship.
On 12th of March 2022. Upon their appearance, along with the required affidavit in terms of Rajneesh versus Neha, who the required details of the affidavit has already been mentioned in the enclosure to the judgment. The petitioner would also deposit maintenance at the rate of rupees 10,000 per month with effect from the month of June 2019 till
December 2023.
till the month of February 2024. Till the month of March 2024.
Lordship.
Till the month of March 2024, which shall be remitted to the opposite party number 2 by the learned court below.
But Lordship, that 2 or 3 installment.
The 50% of the arrears be deposited on 12th of March 2024 and remaining 50% be deposited on 16th April 2024. Yes, the amount be remitted to the opposite party number 2 by the learned court below. Right? बैंक अकाउंट में ट्रांसफर कर सकते नहीं कोर्ट से जमा करा दीजिए दैट इज बेटर
वही सबसे अच्छा रहेगा कोर्ट
Yeah.
में हम जमा कर
हाँ.
देंगे और वहाँ से वो
ठीक है the amount so deposited be immediately released in favor of opposite party number 2. The said amount will be subject to the final outcome
of the
the case before the learned court below. The learned court below is directed to pass a final order after hearing the counsel for the parties. After hearing the parties, latest by 30th April 2020. Right?
अगर वहीं
In
पर settle
case that should be sufficient.
that would be sufficient और वहीं पर अगर 10,000 हो जाता है तो हमको कोई
उससे हमको क्या मतलब है वहाँ क्या होता है You see, this is the operative portion of the order. Dictations will have necessary corrections from here and there. Some quotations from the judgment will also be there.
like that.
This petition is accordingly disposed of. Next.
You can see Mason case, item 75.
My lords were kind enough, my lords, to take it off turn. My lords, without trying to be speaking in either exaggeration or anything else, I have seen various counter affidavits, my lords, putting nearly 36, 37 years. He might go on. My lords, first, before your lordships takes it, I'll try to place my case in nutshell.
Kindly place it fully because I have not gone through this record.
My lords, and then I'll place it because your lordships will then have to come to a decision. What is to be done with regard to such kind of a counter affidavit, given the fact. My lords, the relief prayed for is that the petitioner, who was promoted to the highest hierarchy in the cadre of Jharkhand Engineering Service, to the post of Engineer-in-Chief, come Additional Commissioner, come Special Secretary, with effect from, my lords, 23 to 2022, by notification dated 23 to 2022, with effect from 24/12/2019. Now, by the impugned notification which is contained in Annexure 1, Annexure 17 at page 77, which is dated 17/8/2023, if your lordships will turn, the notification itself tells a story. If your lordships will turn to page 77.
Yes, I'm there.
Has your lordship got
Yes,
that?
I'm there.
Would I read that, my
Yes,
lord, for your
please.
lordship's
Can you read?
convenience? It says, Shri Murari Bhagat, Samprati, Abhiyanta Pramukh, Sa Apar Ayukt, Sa Sachiv, Sa Vishesh Sachiv, Gramin Karya Vibhag Jharkhand, रांची की सेवा ग्रामीण कार्य विभाग से वापस लेते हुए, the services were taken back from the rural department. अगले आदेश तक अभियंता प्रमुख तकनीकी परीक्षक कोषांग मंत्रिमंडल सचिवालय एवं निगरानी विभाग झारखंड रांची के पद पर प्रस्तापित किया जाता है. Without going into anything further, my rank of additional commissioner, my rank of special secretary, by this particular notification has been taken away. Now,
Are you in the IAS cadre?
Sir, I am not in the IS cadre. What was done, the post of chief engineer way back in 1974 was upgraded and given the status of additional commissioner. Then, in 1981, the same, apart from being given a status of an IAS officer, in 81, this was super added, upgraded with the post, with the rank of special secretary.
The reason is that if you say that it's a very straight question and I want to know from you, are you governed by fact?
I'll explain that basically and only bare essential for the day, as I would immediately like to take your lordship to the counter repeat. Therefore, my lords,
you see, we have to be very clear about my jurisdiction. If it is a matter relating to CAT, then I will not entertain.
it's not cash, it's not a service dispute. Not a service dispute.
Okay.
It is only a rank which is taken away. The question at large, or the question which your lordships will have to decide, apart from other questions, would be, my lords, does the state government, respondent state, have the power to post a engineer-in-chief cum additional commissioner cum special secretary to a post which is not sanctioned for the same, which amounts to reducing in rank, which is contrary to the duties statutorily codified in Jharkhand Public Works Department by Clause 15. And larger than is it a bona fide exercise of power or is it malicious? Now, first I will take your lordships to the issue that the pursuant to a kindly turn to Annexure 3. It is the proceeding of the Departmental Promotion Committee. Starts at page 40, my lords.
Yes.
Has your lordship got that?
Yes, I've got it.
Clause 2 at page 40. प्रशासी विभाग द्वारा बताया गया कि विभागीय अधिसूचना सो एंड सो 12/4/2018 से प्रकाशित झारखंड अभियंत्रण सेवा नियमावली 2016 के नियम 7 सपठित अनुसूची 2 में मुख्य अभियंता में मुख्य अभियंता असैनिक का अनुवर्तीय प्रोन्नत पद नाम अभियंता प्रमुख सह अपर आयुक्त सह विशेष सचिव so and so pay scale स्वीकृत है. No, sir, I'll show that from the rules also. उक्त क्रम में पथ निर्माण विभाग द्वारा ये जानकारी भी दी गई कि अविभाजित बिहार राज्य के पथ निर्माण विभाग से अभियंता प्रमुख सह अपर आयुक्त सह विशेष सचिव का कार्यरत एक स्थायी कैडर पर संवर्ग विभाजन में स्थानांतरण द्वारा झारखंड राज्य को प्राप्त हुआ. So therefore, one post of this particular rank, my lords, was transferred by the state of Bihar to Jharkhand on reorganization. तदुपरांत ग्रामीण विकास विभाग झारखंड के स्वीकृत्यादेश पत्रांक 14/8/2001 के से अभियंता प्रमुख सह अपर आयुक्त सह विशेष सचिव का एक स्थायी पद सृजित किया गया. Plus, therefore, this departmental promotion committee, based on the information of the Prakashi Vibhag, takes these facts into account. One transferred, one sanctioned and created on 14/8/2001 by the state of Jharkhand. पुनः भवन विभाग झारखंड रांची के स्वीकृत्या आदेश पत्रांक इतना 17/3/2006 से उप पदनाम का एक और स्थायी पद सृजित किया गया. Lords, for the moment, because I want to take your lordship to the counter affidavit. Lords, I never possibly had the fortune, knowledge, or my lords, the persona to come to that side where your lordships are sitting. It's such a counter affidavit had been filed, and I had the occasion. I don't know, my lords, what I would comment. Are the courts not being taken seriously? Because there is already in the case of the petitioner itself, where one of the benches of this honorable court held that the road construction department is playing games, playing with words with this honorable court. Now, my lords, your lordships have seen this 3 sanction posts. I was granted sanction, notification was issued, which I have read out. Now, my lords, kindly a few paragraphs more. There were specific paragraphs in my writ application, my lords, where I categorically, apart from there, my lords, if your lordships will kindly turn to para 6, Roman 5. My lords, para 6 is a assertion of facts.
Para 6, Roman 4.
Roman 4.
Para 4, then. Just a minute. Where is para 6 page number?
Page 6, para 6, page 8.
Roman 5 will be.
It's Roman English numbers. It's
Oh,
English
no,
numbers.
the prayer portion ends with Roman 4 at page 7. Then this starts. And then,
It is ABCD.
oh,
Para 5 is just resides within the territorial region.
doesn't
Para
matter.
6.
Your lordships are right. Lords, my notes had a wrong entry. Lords, I have made a categorical pleading, and then your lordships will, with regard to the same, my lords. Lords, all the details.
So your basic contention is that you could not have been transferred to this particular
Plus one.
department.
I could not have been transferred to a post which is not equivalent to the post of engineer-in-chief, come additional commissioner, come special secretary. Now, my lord, if your lordships will return, para 8, I have made a pleading, if your lordships will look to para 8. Oh, my lords, Roman 5 was wrongly being mentioned, it should have been, my lords, V. If your lordships will kindly turn to V at page 17. With regard to the 3, apart from the annexure 3, my lords, kindly see, that stated that a 3 cadre post, sanction for the post of it so and so, so and so, it is stated that the 3 cadre posts where are filled up by way of officiating arrangements from by officers who on the date of the posting of the petitioner in the rural work departments were not even substantially promoted to rank of chief engineer. A tabular chart I have enclosed. All the 3 sanctioned posts are being occupied by officers of the rank of superintending engineers or at the maximum chief engineer on officiating basis. The tabular chart is annexure 11. If your lordships would like to see that, kindly see it. What is the way? And annexure 11 page kitna?
59.
Page 59.
Let me just have a hearing from them and figure out if there is any additional affidavit by any competent authority, maybe the finance department, could be required as to whether this post is equivalent or not.
Your lordships, of course, it's your lordships court. Your lordships will not control it in the manner your lordships like.
No,
2 more
because
minutes. 2 more minutes, and then I'll leave it to my. Your lordships has seen the tabular chart, and then I have made in para 8, my lords, various pleadings. Now kindly have a look at the counter affidavit. The writ petition was filed, not in the year 2023. By first order passed in this case, for time was granted to file a counter affidavit. When it got listed the second time for no counter affidavit was filed, the bench of that court, my lords, after imposing a cost if a counter affidavit is not filed by a particular time, I am sorry that it's not been filed, directed a cost of rupees 5,000 to be paid to the advocate's clerk. Now, my lords, kindly turn to the counter affidavit. It's a small counter affidavit. I hope it is on record.
Yes, it is.
My lords, if your lordships will turn to para 4 to 11, my relief in 7 subsequent paragraphs have been quoted verbatim to give it size and substance. Then kindly turn, my lords. It's just relief being quoted.
I've seen that.
Kindly turn to para 11. This is with regard to my promotions, which I have stated, they are admitted therefore. Now kindly turn to para 11. This is the sole paragraph that has come on account. And what do they say, my lords? That so far as the redressal of the claims of the petitioner is concerned, it is to be stated that while letter number 126 dated 11/1/2024, information from the state of Bihar, plus 1, state of West Bengal, Uttar Pradesh and Madhya Pradesh, has been sought with regard to what, if your lordships will kindly see annexure 3, one of the signatory is the principal secretary department of road construction department who was in departmental control. And the whole idea is, my lords, I got promotion to various posts after 5 series of writ petition filed and orders obtained from this court. Now, my lords, I am due to retire in 31st of December 2024. And now they say they should write to the other states also. Why discriminate between the
Yes,
other
why? What
states?
is this? What do you want to suggest? That you will be guided by some information received
And
from
not
other
sanction
states?
post here. I'm only passing on, Milords, in my case
this-
itself.
In this case, the very small issue is involved. 3 posts are the cadre post.
And you post me somewhere else.
Let me complete, sir.
Sir, kindly have a seat. Kindly have a seat. Kindly have a seat.
Uh-huh.
And have some patience. Yes.
3 cadre posts are there. Petitioner earlier moved before this honorable court. By the order of the court, a DPC was convened.
Where are those orders?
It is annexed in the.
All, we have held back nothing. They are all in my
But
favor.
what I'm submitting all are against me.
Then?
But the DPC was convened. By the order of the court, my lord, he was promoted to the post of engineer in chief, come additional commissioner, come a special secretary. In
It is by this particular post is a post, or it is just an additional charges given to
my
you?
lord, it says,
It's
my
a
lord,
post.
that is a cadre post. There are 3 cadre posts with this nomenclature.
Okay.
So in road construction department, Gramin Vikas, we are rural development department, and one more.
And all?
And one more, my lord, it is
You
written.
tell us we have to write orders. You just can't be one more.
Milords, let me pass on the 2016 rules. Copy up, fresh copy.
Tell us. One is in the road construction
Yes, my
department.
lord, the senior has read, my lord, at para.
Annexure 3, if
Annexure
you're
And
three,
other
ma'am.
is in the what? Building construction.
No, one is in road construction department.
Other is
Milords,
Other is Gramin Vikas, the rural development
Gramin, rural
department.
development.
And Pune Bhavan Nirman Vibhag, my lord,
Building construction.
So 3 cadre posts according to the DPC is there. There is no dispute.
Then how do you, where have you transferred him?
He was transferred to the post of engineer in chief in the cabinet vigilance.
What does that mean? Is it of the same rank?
no.
So far as this is concerned, my lord, the additional commissioner, come a special secretary. But I cannot say it is the same.
You cannot say. Or your counter cannot say.
My counter
Or
cannot say.
your authorities cannot say.
So, my lord, I pray before your lordship, my lord. This counter was filed, my lord, 2 days back. When a specific counter affidavit is required in this case from
Who
the
will file
secretary of the road construction.
Why Secretary of Road? Why not the Finance Department? They would be the best one to say.
Because, my lord, there
No,
is no,
because what?
because no financial loss to the petitioner.
No,
my lord.
it is not a matter of financial loss. It is a matter of status also.
Matter of status.
Certainly.
Milords, let the chief secretary file a personal
Or
affidavit.
chief secretary can file it, or the finance department can file it, because he will also seek instructions from finance department only. But this will be subject to payment of some cost. You cannot get away like this.
And Milords, I'm retiring after 7 years. Should I retire from a post befitting my status?
You can't file such a counter affidavit, and you are not clear as to whether the position in which he has been transferred is equivalent to this or not.
Since, my lord, the counter affidavit is silent, so, my lord,
So therefore, you need to seek instructions, right?
Milords, may I point out one thing more, Milords? Possibly it will help your lordships in framing. The Jharkhand Works Department Code Clause 15 sees it talks about the responsibility of the post.
See, the point is, I tell
You know, it
no,
talks about
I
the-
appreciate everything, but the point is, you see, these are the things, you know,
And then-
for actual adjudication regarding the comparative
Milords-
charges and what are the responsibilities. These things should have been mentioned in your writ petition itself, isn't
Absolutely, it has been. Every point by point, fact by fact.
it?
Para
This
six.
has been mentioned.
Yes,
Where
yes.
is it mentioned?
This has also been mentioned.
Let us see where is it mentioned.
Now, see your PW code paragraph, your lordships will find at देखो PW code का है paragraph. In fact, Milords, I have mentioned the clause also.
Para 17.
Possibly, yes. Including the three clauses.
Who will file your counter affidavit? Tell us.
No,
The
let the chief secretary file it, madam. And let the record be placed for one paragraph. I am a person who is supposed to be advising the state government with regard to one of the three work department that I am posted, with regard to all matters. I am the person who is supposed to initiate proceeding for transfer and posting. What has been done? A rank officer of the rank of superintending engineer holding the officiative charge of the engineer in chief.
Yes,
Road construction, madam. Secretary road construction.
Secretary road construction. How will he file? How will he give this fact to you? You file the affidavit of the chief secretary. He's a very high-ranking officer.
Because one paragraph, will your lordship see?
And this should come in consultation with your finance department.
And Lords, one thing more, Lords.
I'll mention it.
Lords, one thing more. The records of this particular transfer posting.
If it is equivalent, if it is not equivalent, you have a case. Otherwise, you do not have a case.
No.
As simple as that.
Correct. Milos, how could it be, Milos, kindly see 15A, 15B.
We'll see that. We'll see that. We'll see that. How
And
much time will you need to do that?
3 weeks.
Milos,
3 weeks.
2 weeks at least.
Why 2 weeks? It's such a simple thing. 1 week should be sufficient. A maximum 10 days.
Even the Lordship is directing the Chief Secretary with
So?
consultation with all departments.
No, not all department. Only the finance department.
At least 2 weeks time. I pray. 10 days your Lordship is going to have
2 weeks.
Learned counsel for the parties are present. The learned senior counsel for the petitioner has stated that the petitioner who was granted promotion and was occupying the post of engineer-in-chief cum additional commissioner cum special secretary by notification dated 23/2/2022 has been shifted to another department,
Milos will use the word transfer and posted.
has been transferred and posted to another department to the post of engineer-in-chief, technical examiner cell, cabinet secretariat and vigilance department, within bracket vigilance wing, Jharkhand Ranchi. The learned counsel has submitted that the promotional post of the petitioner was a cadre post.
The promoted post of the petitioner.
The
I have already
promoted
been
post of the
promoted.
petitioner is a
These are
cadre post,
cadre posts.
and altogether
There are 3 sanctions.
3 such sanctioned posts, one in the road construction department, the other in
The building
the second one in
construction.
building construction department, and third in
Rural works department.
works department.
Yes.
The learned counsel has submitted that by transferring him to the vigilance department, the petitioner has been degraded and therefore the
His
present
status,
petition,
Lordship,
his status has
is
been
taken away.
degraded, and his status has been taken away, and therefore the present writ petition has been filed. The learned counsel for the respondents has referred to the counter affidavit, but has submitted that this aspect of the matter has not been properly responded to in the counter affidavit. He submits that some time may be granted to file a supplementary counter affidavit. Considering the nature of dispute involved in the present case, this court is of the considered view that the counter affidavit should be filed by the Chief Secretary, Government of Jharkhand, respond number 1, and in consultation with the Finance Department and also the Department of Personal and Administrative Reforms and Rajbhasha. It is also surprising to see from the counter affidavit that a letter number 126 dated 11/1/24 has been issued seeking information from other states, which reflects that there is no clarity in the state of Jharkhand, or the respondents or the act of the respondents does not appear to be above board. The letter number 126 dated 11/1/2024 has also not been placed on record. Let the supplementary counter affidavit be filed by twenty-seventh of February, rejoinder by 29th, if any.
Yes. 1 or 2 days more, my lord.
Okay, I'll post it on 4th. Rejoinder by 29th.
My lord, give me a day or two more.
One-
Because they may serve me.
1-2 you have.
1st of March.
Rejoinder by 1st of March. Post this case on 3rd of March 2024. 4th of March 2024 under the heading for final disposal. The parties to also file their short synopsis, list of dates,
Lord, in view of what
and
I-
judgments which they seek to rely upon.
Lord, I have provided a booklet of judgment right from Roshan Lal, Triloki, Dharamveer.
You give me that?
was
And
two
the provision of that code that you were citing. I want that also.
PWD,
Yes.
Public Works Department Code.
Has been forwarded.
Where is that?
I'll just give it.
Lord, your lordships will grant my learned friend, Lord, assisting me. 2 judgments, booklet has been prepared, but 2 judgments are missing.
Which
She
one?
will provide
Which one?
Last judgment.
last 2 judgments.
Okay, you do the needful. Where is that PW code that you were referring to?
Could I pass it out? for
Yes,
your
please,
lordship?
please, pass it on.
Come here.
It should be readily available in the file
My
itself.
lords, yes. Your lordships can take this. Unless I will
Thank
take
you.
it back on 4th, my lord.
Yes.
At times I am required to be here in Jharkhand, I
English
think that's
version
all.
start from page.
Yeah.
Okay.
English
The
version
case
start-
will be taken up for final disposal at 2:15.
My lords, one paragraph, not for anything further. Just read that para 7 and I will say nothing, I will read out nothing. Look at the way I have been slighted in all
We'll
my-
take care, we'll take care.
And therefore, my lords, if records could be there, my hunch is, my assertion is that the superintending engineer has initiated this transfer and posting.
We cannot go into all that, but we'll just find out whether it is equivalent.
My lord, in this case, my lord,
Give me that PW code given.
I have given the version.
Please tie it.
One
Or
judgment is
judgment.
missing from the compilation. That copy I will be providing.
You provide it.
my lord,
Have you
in this
referred to
case-
the paragraphs?
Paragraphs is not referred.
Please,
Oh,
you
I
take
have those
your judgment compilation back, right? You put the paragraph numbers you are referring to.
My lords, I will give my notes to my learned friend, she can include those
You
paragraphs.
just take that compilation back, but you furnish it prior to the next date of hearing, much prior to that, because you know that I will read it.
Yes.
My lord, in this case, the affidavit of the chief secretary will be personal affidavit.
Yes, of course, personal affidavit. He has to bear the responsibility for
Right.
anarchy in the state, isn't it?
And
You
representation will
you are
duly
not
filed.
aware, and you are seeking information from other states is something which is, unheard of.
And then the DPC, Industrial Development Commissioner, the Principal Secretary, Road Construction Department, which cadre is involved, is a signatory to the 3 sanctions for 3
Let
years.
us see, let us see. I'm just verbally telling you, you also bring on record the sanction orders by which these posts were sanctioned. You should bring those things on record,
Yes, my lord.
isn't it? Yes. Kindly give appearance memo of all the council secretaries.
For orders item 32, Criminal Division 480 of 2022.
Yes.
My
Petitioner.
lord, in this case, where I have removed the defect, but
No,
if I
defect
remove
ignored.
my
Defect ignored.
रेट मार्क्स से करना डिस्प्ले ऑर्डर में
ब्लू पेन से उसने किया है, असल में रेड से करना था।
You are for the
Ignored.
notice has not been issued.
No, my lord.
लिखिए. Issue notice to the opposite party number 2 under speed post as well as orderly process for which the recusal should be filed by Monday.
By Monday, 2 ही दिन का 1 week.
You file it by Monday. मुंशी है ना?
मुंशी तो है my lord, लेकिन 2 दिन है।
Notice के लिए you don't need the client. If you want early judgment, then you should file it by Monday. By Monday.
Yes, my lord.
Counsel for the petitioner has submitted that the order of conviction by the learned court below, by learned trial court, has been set aside by the appellate court
Yes,
on the ground that the timeline prescribed under the provisions of Negotiable Instruments Act with regard to service of notice and filing of case has not been complied. But he submits that no right has been reserved with the petitioner to file a fresh complaint in terms of the observations made by this court in the case of Manoj Kumar Nag versus State of Jharkhand reported in bracket 2021, in bracket 2021 Supreme within bracket JHK bracket close 253. Although the state judgment has been relied upon by the appellate court. Timeline तो आप नहीं comply किया, but your right to file fresh complaint is intact by virtue of that. Pose this case on the notice should accompany a copy of this order. आज upload हो जाएगा ये order, download करके इसके साथ में लगा दीजिए. Pose this case on
after 4 weeks in the appear होंगे तब ना।
appear तो होना ही पड़ेगा ना. On 14th of March 2024, awaiting service report, the office to track speed post delivery and prepare appropriate office note in connection with service of notice. Speed post and ordinary process दोनों. Next.
Item 33, WPS 1173 of 2023.
Petitioner. Who is there for the petitioner? Counsel for the petitioner is absent. Respondent is present. Earlier also he was remaining absent. Oh, amended petition has not been filed. As per the office note, amended petition has not been filed. नहीं filed हुआ है. Not sir.
File में
Filed.
served 24/8/23.
So why is this office notice saying not filed?
नहीं हुआ.
नहीं हुआ है, नहीं हुआ है. Not yet.
We have received.
You might have received, but it has not been filed. Time till 22nd February is granted to the petitioner to comply to file the amended writ petition.
Yesterday दिखा है.
दिखा रहा है? तो भाई इस तरह से कोई preemptory order dismiss हो जाएगा. This should come as per inquiry. You want to file supplementary counter affidavit?
Counter to amended.
देखिए WPS number 1173 of 2023 amended as per computer inquiry amended writ petition has been filed. Counsel for the respondents prays for and is allowed time till 29th February 2024 to file a supplementary counter affidavit in the present case. Rejoinder, if any, by 7th of March. Post on 21st of March 2024. The parties to file short synopsis, list of dates and the judgments which they seek to rely upon much prior to the next date of hearing. Counsel is present. Are you appearing in this case?
No, ma'am, I'm not ready. Actually, Mr. Saurabh Sekar.
It's okay. Give your appearance. Defective.
The heading for orders verified item 2, Criminal Division 207 of 2022.
You are for the accused?
Yes,
No. This is maintenance.
Yes,
You have challenged what order? Interim maintenance. What have you challenged? You do not know.
I will let you know. One week time.
Time till 7th of March is granted to remove the surviving defects peremptory. If the defects are removed, post this case on 14th of March. 7th March would be too long. Or 29th February kariye and post on 7th March. Right? Time till 29th February to remove the surviving defects. If the defects are removed, peremptory. If the defects are removed, post on 7th of March 2024. Under appropriate heading. Peremptory order. Next.
Item 3, Criminal Division 238 of 2022.
In all the cases, I am passing the same order.
Yes,
One order, all peremptory orders, right? Till 29th, you have to remove the surviving defects. And if the defects are removed, all these matters will come on 7th of March.
Item 5 is wrong.
It will be wrongly listed as 5. That's all. 2 weeks हो गया, काफी है, चलिए। और अगर DFD हो गया ना तो cost के बिना हम restore नहीं करेंगे. This much I can tell you for sure. In maintenance case, if the case is dismissed for default, whatever be the quantum of maintenance, उससे दुगना cost हम लगाएंगे.
सीरियल 15 पर मैडम उसमें क्या हुआ है कि हम अपोजिट पार्टी से हैं और 4000 रुपया कॉल था, उसमें मेंटेनेंस देने का बच्चा भी है और डिफेक्ट फाइल करके अभी तक
कोई बात नहीं. DFD and you see you are also right. If the defects are not removed within time, office is directed to prepare appropriate order regarding dismissal of the case and communicate the same to the learned court below for necessary orders.
ऑलरेडी पहले मेमो आता था
कुछ नहीं आएगा, अब सीधे वहाँ पे कम्युनिकेट हो जाएगा, उसका वहाँ करते रहिएगा.
पहले मेमो मिलता था डिस्मिसल रिपोर्ट वाला
कुछ नहीं मेमो आएगा.
आइटम नंबर 3
Item number 3, you are on record.
Yes.
The learned counsel for the petitioner submits that he does not want to, on instructions, he does not want to press the present petition. Accordingly, this petition is dismissed as not pressed. 3, you put your signature.
Sign कर दें.
नाम बताइए अपना. Your Lakshman Kumar. Next.
For press filing item 34, WPS 4656 of 2023.
Yes, petitioner. Counterfeit.
This is the ECP and university matter. It was posted in the post of stenographer
then the notice may be issued, Your Ladyship, to the respondent number.
Respondent number. Notice has to go.
Yes, Your Ladyship. As Registrar General, Jharkhand High Court, and Deputy Secretary for Honorable Governor, respondent number 545.
Okay. The learned counsel for the parties are present. Issue notice to respondent number 2, 4 and 5. The notice be served upon respondent number 2 and 5 through speed post as well as ordinary process, for which requisites be filed by Monday. Office to track speed post delivery and prepare appropriate office note in connection with service of notice. So far as respondent number 4 is concerned, the notice be served in the office of learned Registrar General along with a copy of this order. Let a counter affidavit in the present case be filed by 14th of March. Let a counter affidavit
By state.
be filed by the state as well as the aforesaid respondents by 14th of March. Rejoinder, if any, by 21st of March. Post on 4th of April. Yes?
Your Lordship, in serial number 20, will there is one defect to delete a prayer, Your Lordship. There are 2 prayer and revision, Your Lordship.
You were not there. There are all, you have been, you can remove the defects. I have given time.
Order may be passed to delete 1 prayer, Your Lordship, serial number 20, Your Lordship.
See, I have already passed the order. It can't be modified like this. So many orders are to be signed. If you want anything to be done, then you have to file your IGA and get it done. 2 weeks time has been granted to remove the surviving defects. And if you want to delete it for that, you can delete it in the office. What's the big deal about it? Isn't it?
Item 35, WPS 4714 of 2023.
Yes, petitioner.
Serial. The private respondent is junior to me, my lord, but he has been promoted to the post of head Morbi, my lord. And my educational certificates were kept under verification. That has been verified. And but my lord, the void annexure 5, after promoting the private respondent, a report was sent to Jack.
This is covered. This is a state within the meaning of Article 12. Madrasa?
Madrasa, yes.
Yes, means. What kind of aid are you getting from the government?
Yeah, the government gives the aid.
What aid?
Educational aid for running the madrasa.
The writ petitions are being entertained in these cases?
My lord, may see an
Or you have a remedy under Jharkhand Education Tribunal?
My lord, since my lord, the promotion is.
No, we do not know. Do you have a remedy under Jharkhand Education Tribunal? You are not aware.
This is a matter of appointment, Your Lordship. Madrasa has to take decision, Your Lordship. So, there is an alternative remedy under Section 8, Your Lordship.
Jharkhand Education Tribunal, no?
Section 8, Your Lordship.
Eight.
It may be verified, Your Lordship.
Let me verify.
Counsel for the parties are present. Counsel for the parties are directed to its counsel for the petitioner is directed to examine and address this court as to whether the petitioner has an appropriate remedy under Section 8 of Jharkhand Education Tribunal. You also find out whether these kind of matters are filed in Jharkhand Education Tribunal or not. Okay? Pose this case on Monday under the same heading. Next. I think this I had indicated on the last day also.
Item 36, WPS 4724 of 2023.
इसके साथ ना झारखंड एजुकेशन ट्रिब्यूनल का नेट से डाउनलोड करके आगे दिखा दीजिएगा इस केस में.
As per the light of the order dated 1st February 2024, IA has been filed.
IA number 153.
Confining the prayer made in the writ petition. You are
Yes.
confining it to what prayer number?
Prayer number A, part of the prayer number 1 and prayer number B, A or B may be deleted, my lord. And further prayer in IA for the only for the pension to extend of the including all the retirement benefits.
Where is your IA? What all do
IA
you
number
want to delete?
1534. Yes.
Delete prayer A. Please.
Last part of the pension running.
Okay, this is being deleted.
My
Okay.
and prayer be completely deleted.
Prayer B is completely deleted.
Yes.
Okay. Then
Only prayer for the retirement benefits.
which prayer do you want to retain?
Part of prayer A.
Part of prayer A, last.
Last 4 lines.
You have issued him charge memo.
Departmental proceeding is going on.
So you have not taken it to
We'll
Lord
file a
JM.
reply, Your Lordship, that what is the present stage of the proceeding, and as well as his new.
Petitioner has been retired, madam.
So you cannot, the charge memo will not be there.
No, there is no.
They cannot continue with.
No.
No, they cannot.
Yes, madam.
When the charge memo is already issued.
Already this has been disposed as annexure 5 and 8, madam. Annexure 5, page 25. Already.
It is just an inquiry report. Has it been accepted finally?
Yeah, in page 28.
Your departmental proceeding has been dropped against you.
Yes, madam. No.
Where is that order?
Page 20, kindly page 28, madam.
28.
28. निष्कर्ष प्रपत्र का कि गठित आरोप और आरोपित प्रपत्र में लिखे जवाब और अपने बचाव के पश्चात बयान में प्रस्तावित.
This is not the order of the.
No, this is by the inquiry officer.
This is by the inquiry officer.
Thereafter, again, annexure 8, review of this
No.
charge memo K.
Just a moment.
Yes.
WPS number 4724 of 2023. Counsel for the parties are present. IA number 1534 of 24 has been filed for deleting certain prayer in the writ petition. And the learned counsel for the petitioner submits that the petitioner is now claiming only the retirement benefits as the petitioner has retired in the month of January 2023. The learned counsel for the petitioner has submitted that in the departmental proceeding, the inquiry report has been annexed at annexure 5 series.
And again, review has been done in annexure 8. Yes, yes.
And
5 and 8.
certain more orders have been annexed. The learned counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case, bringing on record the final order which might have been passed in the departmental inquiry. In the meantime, the IA number 1534 of 24 seeking amendment in the petition is allowed. The petitioner is directed to carry out the necessary amendments in writing during the course of the day. How much time do you need?
Four weeks.
4 weeks to file, bring on record whether the final order has been passed or not.
No, all the other things, Your Lordship.
What other things?
Because the inquiry report and whether proceeding has.
Everything is brought on record. Let the counter affidavit be filed by 7th of March, rejoinder by 14th, post on 20th of March, under the heading for final disposal. Next.
Permission item 37, criminal division 23 of 2022.
Yes, petitioner.
May I please hold it? My lord, this revision is directed against the order dated 13/9/2019, wherein an application for discharge filed on behalf of the petitioner has been rejected by the learned court. But the offences for which the FIR has been registered are under section 498A, 323, 504, 506, read with section 3 and 4 of the TPI, Story Prohibition. At the very outset, my lord, I will request the leadership to kindly produce the FIR that has been registered against the petitioner, along with his mother and father. There are basically 3 accused persons in this matter.
FIR will not decide. It is not a complaint case.
Just for the brief facts of this case, I will say.
No, you tell us that what is the so glaring illegality? The basic ingredients are not satisfied.
Certainly, there are basically 3 folds. The reason to challenge this order are basically 3 folds. Firstly, that there is an inordinate delay in lodging of the FIR.
Delay is a ground.
Delay is a ground. Secondly, there is a lack of.
How much is the delay? What is the date of marriage?
Date of marriage is marriage was solemnized in the year 2012, 24/4/2012.
Okay, 24/4/2012. When was the case filed?
That is on 10/6/16.
10/6/2016. So this is a delay of around 4 years.
4 years.
So this delay is hit by which provision of law?
By 498 itself, which says that from the cause of action, the case has to be lodged within a period of 3 years.
Where is it? 498, there is a limitation prescribed.
No, certainly not. There are certain judicial pronouncements.
No, we do not know. You tell us the judicial pronouncement. That there is a time limit prescribed for lodging a case under section 498A.
But my lord, this has to be appreciated that this
This is not the stage. In revision, we cannot appreciate that.
Moreover, madam. Moreover, the second round.
That is all. What else?
There is my lord, the contention of the conduct of the informant had also been seen, my lord, because just because this petitioner was supposed to go to foreign country for his job.
We cannot see your defense at this stage.
My lord, this is the remedy that we have opted for.
We cannot see your defense at this stage.
Certainly.
Now, my lord, the charges has also been framed.
What is the stage?
3 witnesses out of 6 have been examined, my lord, by the learned trial court.
Okay, okay. Criminal revision number 23 of 2022.
My lord, may permit
the learned counsel.
I may be permitted to withdraw this with the liberty to take all these grounds that you have tried.
After some argument, the learned counsel for the petitioner seeks permission to withdraw this petition. Permission is accorded. Dismissal of this accordingly this petition is dismissed as withdrawn. Withdrawal of this case will not prejudice the case of the petitioner in any manner before the learned court below, and it will be open to the petitioner to take all points which may be available to the petitioner as per law.
Next.
Item 38, criminal division 96 of 2022.
Petitioner. Who is for the petitioner? सेकेंड हाफ में कंटिन्यू है ना बेंच पास ओवर करिए कि 15 में टेकअप करिए इन्फॉर्म हिम you also go through the records. If he doesn't come, we'll decide the case.
Yes.
Item 39, criminal division 138 of 2002.
Yes, petitioner. What is the matter about?
Matter is very peculiar matter. The father of the petitioner has filed a maintenance case.
Against
and
whom?
maintenance case has been allowed expert.
Against whom?
Against the sons, 3 sons. I am one of the sons. This has been
So
allowed.
order has been passed only against you.
No, all the three sons.
Okay, all the three are petitioners before
No,
us.
only one of the sons. The petitioner
Rest
is
rest of
Shahid
them are not
Iqbal
aggrieved.
Haider.
Rest of them are not aggrieved.
Lordship, they are staying with his father. The main intention is that the father of the petitioner is retired BSL employee. And
Retired?
he has BSL employee.
Okay.
He is getting a handsome pension also. And this petitioner has been ousted from the house long before. The petitioner is having a small tea shop. Small
You were
shop.
not served with the notice?
No, Lordship. I have stated in para 4 of my petition. Notice was served to OP number 2 also, and OP number 2 has also filed their document. And date of knowledge of this petitioner is on 25/12/2021. A person from the locality informed him that his father stated that he has won a maintenance case.
Learned counsel for the petitioner and opposite party state are present. The learned counsel submits that the impugned order of maintenance in original maintenance case number 122 of 2019 by learned additional principal judge, additional family court Dhanbad has been passed on 15/3/2021, which is an ex parte order, and no notice was ever served upon the petitioner.
Lordship, a notice has been some, an enforcement notice has been also served.
Yes.
Yes,
After
Your
the
Lordship.
after
Please do not.
125.
And as per his statement made in paragraph 4 of the petition, he has submitted that the applicant before the learned court below is the father of the petitioner, and you have not made others as pro forma party. Who will teach you this? Yes?
Lordship, I will make the course of the day.
The petition was filed against three sons of the applicant. The learned counsel has also submitted that the applicant is receiving pension.
Yes, Your Lordship.
Your Lordship,
As per my knowledge, he is
Your
retired.
knowledge is derived from where? Which paragraph?
Your Lordship,
I have written in my grounds portion.
Yes, madam.
Your Lordship, in this,
Just
Your Lordship, he has been getting jail also for this, as he has been dismissed from the he's doing CL service and he get dismissed.
Are you representing the state or the opposite?
OP number 2, father.
You are representing OP number 2. You have
He is
entered
not getting
appearance by
any
filing
pension.
wakalatnama?
Yes, sir. He's not getting any pension from this.
Okay. The learned counsel has submitted that the father of the petitioner, who was the applicant before the learned court below, was in government service and was getting pension. The learned counsel appearing on behalf of OP number 2 has submitted that no pension is being paid by the applicant is not getting any pension. How do you say that the notice was served?
Yes, Your Lordship, enforcement notice.
Enforcement notice is a separate thing. Notice under 125 is separate.
Yes, 128 under.
125 was maintainable, there is no dispute, right? This judgment was passed on 15th March 2021, right? The required disclosure in terms of Neha versus Rajneesh has been made in this case?
No, Lordship.
Then how this order will sustain? Tell us.
Yes, Lordship.
You examine it, both of you, at least read it if you have not read it once. Citation in लोगों को दे दीजिए. Madam, you go through it. The matter is required to be remitted back, right? You read this judgment. The citation दीजिए और इनका computer में खोल दीजिए system. Give them the citation. You come at 2:15 because on account of non-compliance of that judgment, this order has to go. Come at 2:15. We'll pass up. नया वर्सेस जजरीश ना आपको दे भी दीजिएगा इसको थोड़ा और ध्यान से देख लीजिए कॉल
Item 40, Resolution 297 of 2022.
petitioner
Lordship, this revision is filed against order of maintenance. Maintenance that is granted is 1500 to petition number 1 and 750 each to petition number 2 and 3. Petition number 2 and 3 is represented by petitioner number 1. She is the mother of petitioner number 2 and 3. Lordship, the maintenance that has been granted is too little amount for them.
it was contested. What is the opposite party doing?
Lordship,
What is his engagement? Opposite party, is he unemployed?
No, Your Lordship.
How do you say? Notice has not been issued?
Notice has been issued, but the OP has not acted.
Notice is served.
But OP is not appearing.
You read the order. Read the order.
The infant maintenance case has been filed by the petitioner Srina Bibi along with her minor son and daughter named Munawar Sheikh and Mafura Khatun against Sergeant Sheikh, being her husband and father of.
You just come to internal page 9. Internal page 9, read para 8. Read it, please. On perusal of evidence of parties. Have you got that? Page number 47. Running page 47.
On perusal of the evidence of the parties and their pleadings, there is no dispute that petitioner number 1 is the married wife of the OP and petitioner number 2 and 3 are the minor son and daughter of the OP. It has also clear from the record and evidence of the petitioner that OP has performed second marriage and OP never cared upon his first wife and his 2 minor children who have born from his wedlock. He has also
You read further. The
the
contention.
contention of the learned counsel of the petitioner that OP has also tortured and assaulted her and demanded ₹1 lakh from her, and due to non-fulfillment of the illegal demand, he also tortured her mercilessly and drove her out from the house of her husband. It appears from the record that OP has performed second marriage with Mastara, and during the living in the parents' house of petitioner along with her 2 minor children, OP did not take care upon them nor bear any expenses for their livelihood. It is admitted in the self-evidence of OP and pleading of petitioner, which is not considerable at this stage. But in the evidence of PW1 and self-evidence of OPW1 has deposed that OP tortured and assaulted her and drive her out from his house. In this context, I have perused the evidence of the petitioner and find that petitioner has stated that OP is the owner cum driver of his 10-wheeler vehicle and earns ₹40 to 45,000 per month. So petitioner has deposed that he has landed property also. but no supporting document has been filed by the petitioner to prove the income from the landed property and income from her own vehicle of OP. Further, it is important to mention here that OP ousted his wife from his house and he did not pay any expenses for their maintenance. In the present case, OP leveled an allegation that petitioner has left his house voluntarily and she did not live with him at his house, but according to which OP has not been able to establish.
Criminal Revision number 297 of 2022, in spite of service of notice, the opposite party number 2 has not entered appearance. The impugned order, the learned counsel for the petitioner has submitted that the impugned order of maintenance of rupees 1,500 per month to petitioner number 1 and rupees 750 each per month for petitioner number 2 and 3 is a meager amount, and therefore the present revision application has been filed. She has submitted that the impugned order was passed on 10/1/2022 and it was the specific plea of the petitioners that the opposite party had substantial source of income as he was the owner cum driver of his 10-wheelers vehicle and also earned rupees 40,000 to 45,000 per month. She submits that the learned court below has recorded that no document was furnished by the petitioner to substantiate such statement and has passed the impugned order. She has submitted that though the judgment passed in the case of Neha versus Nazrish has been mentioned in paragraph 10 of the impugned order, but the learned court below has completely failed to take care of the directions issued by the Honorable Supreme Court in the case of Reha versus Nazrish, where the parties were directed to where in all the pending proceedings for maintenance, the parties were to file their necessary disclosures in terms of the enclosures to the judgment itself. The said judgment was made applicable to all the pending proceedings in terms of under Article 142 of the Constitution of India. The learned counsel submits that the opposite party, the learned court below, ought to have asked the parties to file such affidavit, and had such a process been undertaken, the true income of the opposite party number 2 would have been placed before the learned court below for appropriate order. Merely because the petitioner, being the applicant, was not in a position to file supporting documents in connection with the income of the opposite party, the same could not have been a reason for passing an order for only a meager amount of maintenance. After hearing the counsel for the petitioner and upon going through the impugned order, this court finds that a finding has been recorded before the learned court below that the petitioner number 1 is the wife and is the wife of the opposite party, and petitioner number 2 and 3 are minor son and daughter of the opposite party. It appears from the records of this case that only a meager amount of rupees 1,500 has been granted to the petitioner number 1 and rupees 750 each for petitioner number 2 and 3, and it appears that the learned court below has recorded that though the petitioner had stated that opposite party number 2 was the owner cum driver of his 10-wheeler vehicle and earned rupees 40 to 45,000 per month, but and also had landed property, but no document could be filed by the applicants, and therefore such an amount has been awarded. This court is of the considered view that in view of the judgment passed by the Honorable Supreme Court in the case of Neha versus Rajneesh, the learned court below ought to have called upon the parties to file their necessary affidavit in terms of the enclosures to the judgment, but the same having not been done, the impugned order cannot be sustained in the eyes of law. Accordingly, the impugned order is set aside and the matter is remitted back to the learned court below to take appropriate steps in terms of the directions issued by the Honorable Supreme Court in the case of Neha versus Rajneesh, and pass fresh order within a period of 4 months from the date of communication of this order. Since only a meager amount of maintenance has been granted, and the opposite party number 2 has not disputed the quantum of maintenance to the extent it has been granted by the learned court below, the petitioner would continue to be entitled for the amount of maintenance which has been fixed by the learned court below. Of course, the same would be subject to final outcome of the fresh order to be passed by the learned court below pursuant to this. There will be modifications and changes in the order, but I am keeping your maintenance amount intact because that's a very small amount given, and that will be subject to the final result. Okay. That's all.